Okay.
Except you can't hear me.
So why don't you just take it away, Sean?
Okay, Clint. All right. Well, thanks for having me here. We're going to have a great hour, talk about some pretty interesting things with regards to caregivers in the situation.
We're going to get her all taken care of here.
All right. There we go. Oh, we got tech support just showed up. Hello, I'm chatting now.
Okay, we
There.
got it.
Okay.
Yippee-yi-yo-ki-yay.
Yeah, yeah. Well, yeah. Users unite. All right. Well, let's start again, shall we?
Yes, start again.
Linda, thank you for having me here. It's a really special day, actually. I'm kind of excited to discuss these issues. Seemingly on their face, they can be a little, I don't know, less than interesting. We talk about estate planning and incapacity planning, and my goodness gracious, you use the word Medicaid, and a lot of people will just, fall asleep in their chairs, mostly because they don't understand the relevance of it and why it's so important. In the situation of a caregiver, and I've been doing this for 32 years, working with caregivers in an elder law situation. I've been practicing and helping the aging population deal with incapacity, dealing with mortality. And one of the big issues that we deal with is dealing with the whole idea of how to pay for the cost of long-term care, either in a setting like your home, an assisted living facility, or a nursing home. And that's a pretty big deal. If you run into that situation, and again, most people don't, they're just kind of living their lives. But as they grow older, as a caregiver, if you're dealing with your spouse, for example, or as your parents grow older and their ability to take care of themselves start to wane, the family, the son, the daughter, the spouse, the sibling can show up and act in the role of a caregiver. Very, very, very good thing. The problem that I see, however, is in a caregiving role, we have a situation where there is, how should I say this? The caregiver tends to burn out over time. The needs of the person being taken care of and the ability of the person providing that care kind of do this. They separate. So the needs increase and the ability decreases. And at some point in time, you get to a point where it breaks, where there's, the caregiver no longer has the ability to perform the services that they're trying to do. And at that point in time, we're looking at supplementing their abilities either by bringing some help inside the home, perhaps advancing to an out-of-home type of a situation in an assisted living facility, or in many cases, when you've gone further down the caregiving road, looking at care inside of a skilled nursing facility, which is also known as a nursing home. The problem, what's the problem with all these things? Cost. If you look at the average cost of care in Pinellas County, for example, you're looking at care running in anywhere from $10,000 to $12,000 a month. And if you look at $10,000 to $12,000 a month, that's pretty significant. And being that much money, you have a situation where but the, I guess, richest of us are in a place where that kind of negative cash flow will significantly, and when I say significantly, I mean incredibly so, wipe you out. It's a negative cash flow situation. You have more money going out than you have coming in. And because of that, it's financial catastrophe. If you start taking more money out of your savings and out of your resources, eventually you'll get to a zero number. Right. And that's an unfortunate reality. So in order to avoid that situation, we need to find some sort of source out there in order to augment or add to our ability to pay for that care. And that's where Medicaid comes into play. And that's why it's such a big deal. Medicaid has the ability to actually pay for all of the costs of that care inside of the nursing home, minus the person's income. So it's basically all the cost of that care, minus a contribution of their income in the worst case scenario. So all of a sudden, a $10,000 or $12,000 a month bill effectively goes away because of the effect that Medicaid has in the situation. But here's the rub. Medicaid is not like Medicare. Medicaid is a situation where you have to qualify for this and meet certain financial eligibility tests. Medicare, basically, all you had to do is be over 65 and paid into the system while you were working. Right. At that point in time, Medicare, it becomes your primary health insurance as an older person. The problem with that primary health insurance, that Medicare with an R, is that it has very limited coverage for the situation inside of a nursing home. That coverage is limited to 100 days, usually post-discharge from a hospital, 100 days of care inside of a nursing home situation. Okay, great. That is a little bit of a problem. And then on top of that, however, it's not a full coverage for the full 100 days under Medicare. Medicare typically pays for the first 20 days of a nursing home stay, and it'll pay 100% of that stay. But let's say day 100, day 21 through 100, you have a situation where you're on private pay, basically. And what private pay is, well, get your checkbook out because it's time to start paying out of your bank account. Private pay at day 21, there's usually about $180 a day copay through day 100. That copay is, I guess, offset if you have a Medicare supplement policy. Most Medicare supplement policies will pay for that copay. The bottom line, however, is once you've extinguished that 100 days of coverage and you get to day 101, at day 101, that's when you're writing the full check to the nursing home, and that can be pretty big deal for the sake of the client. So that's where we want to make sure that we're eligible for Medicaid to pay for the cost of that care. For the last 32 years, that's been one of my missions in my practice, is to help families deal with that particular problem. It's kind of a strange issue. You graduate from law school and you're going to go out and be a lawyer. And what do you end up doing? You end up helping families preserve their life savings from the cost of long-term care. Kind of a strange, I never envisioned myself when I was in law school doing this, but I can tell you it's incredibly rewarding. And we're very good at doing what we do. In order to qualify for Medicaid, though, you need to meet certain financial eligibility requirements. Medicaid was originally created as basically healthcare for poor people in the late 60s. Under President Johnson's administration back in the day, he was trying to get healthcare for all of us in this country. That didn't go over so well, surprisingly so. It was pretty much defeated in Congress, but as a consolation prize, I guess, if you wanted to say, Johnson was able to salvage Medicare, which is basically healthcare for older people. And then he created a program called Medicaid, which was in essence healthcare for poor people. So if you're old or poor, then you can get your healthcare covered in the United States. The weird thing about this, though, is when he created these two programs, the coverage, really the main coverage for nursing home stay in that setting, wasn't put into the healthcare coverage for older people, except for that 100-day thing we were talking about. It was put under the healthcare for poor people coverage under Medicaid. That's kind of an interesting choice. In retrospect, it seems kind of silly. So what happened in our country is that we had a situation where we were becoming a nation of poor old people due to the cost of healthcare. In 1988, however, there was a significant change in federal law, which was a big deal, because what they did is they reached down into the Medicaid law. And what they did is they adjusted the eligibility requirements so that you didn't have to be as poor as you used to in order to cover or in order to qualify for care to pay for the cost of nursing home care under Medicaid. This happened in 1988. It was a very, very big deal. And what it did in essence is it created in essence a new middle class entitlement for older people in order to help pay for the cost of their care in a nursing home. Very interesting. They opened up the eligibility requirements, made it a little bit easier. So let's take just a half a second and talk about what those requirements are. They're different from state to state, by the way, which is an important point. Every state's law is unique unto itself when it comes to Medicaid. There are, in essence, 50 different Medicaid laws in this country. They're generally guided by federal law, which kind of gives you the guidelines of how Medicaid should work. And then the states come in and kind of fine tune and tweak it to their own particular situations. So Florida is like this. Florida has two different things they look at in order to determine eligibility for Medicaid. The first thing they look at is what the income is of the individual that's applying for benefits. The second thing is how much money do they have? So the way I like to say this is that the state of Florida looks at what you get and what you got. What you get is your income. What you've got are your assets. Now, this gets a little different and a little particular regarding whether or not you're a single person or whether or not you're married. the numbers change slightly, to say the least. If you're single, you're allowed to have $2,523 of gross income on a monthly basis. That's your Social Security, that's your pensions, IRA distributions, whatever your income is, you have to be below $2,523. Now, that's the number for this particular year in the year 2022. Every year, that income limit or cap is adjusted based upon, I guess, kind of like the COLA is with your Social Security amount. So this year, 2022, our number is $2,523 of gross income. That's an important point too. The gross amount is not the money that you actually are receiving in your check or being deposited in your bank account. The gross amount is before they take out any deductions. And people that are on Social Security, you're depositing your Social Security check into your bank account. That's not really what the government is paying you under Social Security. They're taking out Medicare Part B, and Medicare Part B, $170. In order to determine your actual gross income, you have to add that back in to your income to raise it up, or I say gross it up to the actual number. And when it comes to this whole idea of this income limit or cap amount, you're looking at, even being $1 over the limit is a disqualifying situation. So that $170 can actually make a big difference. On the asset side of things, the assets of the individual who is single trying to apply for Medicaid benefits to pay for their cost of their nursing home care is limited, and this is kind of crazy. You can only have $2,000 or less in countable assets. That's not a very big number, all right?
No.
$2,000 or less. Some things are not counted as part of that $2,000. Your home is not counted as part of that $2,000. The value of your home, the value of your car is not counted as part of that $2,000. But your investments, your checking account, your savings account, money market account, annuity, all those things that are out there, if you have more than $2,000, you are disqualified from Medicaid benefits. One of my jobs is to make sure that you meet that eligibility requirement by, how shall I say this, by us preserving those funds, by recharacterizing them, by moving them in a way that Medicaid allows you to do that in order to get down below that $2,000 number. And many of my clients are intimidated by that. They hear that number and they're like, oh my goodness gracious, I have way more money than that. I'm never going to qualify for Medicaid. So why are we even talking? And that's actually not reality.
That's why we're talking.
That's why we're talking, exactly. So in my situation, when a client walks in and we're dealing with their financial picture, whether they have $20,000, $50,000, or $100,000 in their bank account, I can still qualify them for Medicaid benefits and preserve and protect those assets by, again, changing their characteristics or moving them in a way that Medicaid allows us to do that to get down to that $2,000 number. Now, if you are married, that's a little bit of a different situation. So for all intents and purposes, in a married couple situation, the married couple combined between him and her are allowed to have up to, let's just say, $140,000 in assets. That's a much bigger asset target to hit. And what that means for my clients is when we're dealing with this problem is that, well, if you come in and you're married, there is at least a chance that you have $140,000 or less in assets, which means we may not have to do a lot in order to move or preserve or recharacterize assets in those situations. Regardless, if you have more than 140 as a married couple, we still have work to do in order to get you down to where we need to be. And again, that's something we do routinely and we've been doing for 32 years. And I guess I can say this, in almost every single case, we're successful in accomplishing that goal. I can't think of a case in 32 years where we were not able to accomplish that goal. Now, this distinction here between assets and income, I think, is important. The distinction specifically is that in an asset part of the problem or dealing with Medicaid and assets and how much stuff you can have, Medicaid looks at what the assets are of the husband and the wife combined together. It's his, hers, and theirs. There's no distinction between the fact that the wife goes, well, hey, that money's in my name. It's always been in my name. It's not his money, so it shouldn't be counted as his money for Medicaid. That's my money. Or even or even further down that road. Not only that, but we have a prenuptial agreement. In that prenuptial agreement, it says what mine is mine, what's his is his, and mine's not his. So don't count my money for Medicaid eligibility purposes, the spouse would say. Medicaid doesn't care whether you have a prenuptial agreement. That's not part of their deal. They just look at what you got, what your agreement is with your spouse as to what you're supposed to do with that, whose name's on the bank account. Any of that is irrelevant. If it's in either of their names, it's counted against them as an asset for purposes of determining eligibility. On the income side, we have a little bit of a different situation. When it comes to looking at income, how much income the person, we don't combine the incomes of husband and wife. It's only the income of the person who's applying for Medicaid benefits that's counted. That's that $2,523 number, $2,523 number that we were talking about before. It's only the income of the person applying for benefits that we're looking at. So what?
For one second, somebody's texting in a question because they're driving.
They're driving.
I hope they're pulling over when they're doing this. And she said she's 70 and her boyfriend is 72, and they were thinking about getting married. So would they be better off not getting married?
Well, it's very, yeah, I've actually had this problem multiple times actually in my practice. And it depends on their circumstance. Sometimes it makes sense to do that. And sometimes it doesn't. One particular case that I remember in this case, in this situation, is it was a man and a woman who had been together for many, many years. They had combined their assets together. They had about $80,000 in assets in CDs and bank accounts. His name was on it, her name was on it, but they were not married. So all of that money that was in those bank accounts that were joint with him and her, he was in the nursing home, by the way, were counted as his money. He was single. He was only allowed to have $2,000 in assets. And that was a problem because her money was destroying his eligibility because it was in this joint account.
Right.
So what we did, this is kind of crazy. What we did in that case is I actually set it up where they got married. And as weird as this gets, I went down and actually performed the ceremony for them, got their marriages licenses. They said I do in the nursing home. And as soon as they said I do, they were a married couple. And because they were a married couple, they had a larger asset number that they could deal with, and it solved the problem. So marriage for them was a good idea. It can work in the opposite result. It can be the opposite too, though, because all of a sudden, if her assets are not part of his assets and her assets are in her bank account, as soon as they say I do, that's now counted as his money. And now they have to meet that $140,000 test. So
I should text her back, call Sean and talk to him, and he'll tell you to get married.
Well, it's one of those cases where, and this is kind of a little bit of a joke. I have two favorite answers as a lawyer. If any client ever asks me a question, I have two favorite standby answers. And one is it depends. And the other one is maybe.
Yeah.
So, and that really means is that it's so very contextual as to what your exact situation is for me to be able to answer it specifically. It can have and it would have an impact. One, it could be positive and it could be negative. So,
okay.
Very good. All right. So back to this income thing that we were talking about. Income is a pretty big deal because it can destroy your eligibility for benefits. And when I first started practicing in 1990 here in Florida, if a client were to come in to see me and they had over the income limit to qualify for Medicaid benefits, I did not have a solution. There was not a solution for them to qualify for Medicaid in the state of Florida. My answer to them was to move to the state of New York, because New York doesn't have a limit on how much income you can have. They don't have that law in New York. So if you get in your car and you drive to New York and you apply for Medicaid benefits, your income there would not disqualify you like it does in Florida. That was the case for many years, until there was an interesting case out in Colorado, where a Medicaid applicant was trying to qualify for Medicaid. And by the way, Colorado has a cap limit like we have in Florida. And they denied him because he had too much income to qualify for Medicaid benefits. This guy obviously was not happy about it. He kind of lawyered up, I guess what you would say. And I always like to say that this lawyer that he hired was apparently awake during constitutional law class in law school. He made, not one of my favorite classes, by the way, but interesting. So this guy made an argument that said that this guy, whose name was Miller, by the way, wasn't being treated fairly under federal law. And the Constitution of the United States says that you have to be treated the same if it's a federal law, whether you're in Colorado or Florida or New York or New Mexico, you need to be treated the same, equally. The lawyer argued that he wasn't being treated equally. And the federal district judge in Denver said, you're right, Mr. Miller, you're not. And so what the judge did, in essence, is he created a solution where this guy, Miller, could put money into a trust each month. And for every dollar that he put into that trust, that dollar would subtract from his income. So he could reduce his income below the cap by making a deposit into this checking account in the name of the trust each month.
Wow.
This was huge. All of a sudden, the problem of having too much income disappeared overnight. The federal government, about a year later, wrote it into the federal law, the ruling in this case. And we were so excited about this as lawyers. We're like, oh my gosh, this is the greatest thing, because now we can fix these problems for our clients, is that we named the trust after him, and we called it a Miller Trust for many years. We don't use that term so much anymore. It's known as a qualified income trust, technically qualified income trust. People throw around acronyms. It's a QIT. I just call it, when I'm talking about it, an income trust. And what this thing does now is it will allow us to qualify for Medicaid benefits regardless of what your income is. You got to have it in place. You got to have it funded properly. Really not that big of a deal. The one issue that I run into frequently, however, in the whole idea of setting up this income trust thing for clients to solve the Medicaid over income problem, is that a lot of times it's being, or trying to be, established by a person acting in the role of a power of attorney. So if you think about the setup here, dad's in the nursing home. He's kind of lost his brain a little bit. He's not really competent or cognizant, no longer has capacity. So the son shows up. He's trying to qualify dad for Medicaid. Dad has too much income to qualify for Medicaid. He's over the limit. So we want to put an income trust in place to fix that problem. Awesome, great. Except the piece of paper that the son has, this power of attorney document that the son has, making him the power of attorney, nowhere in the language in that document does it say that he has the ability to create a trust. It's just not there. He can sell property, he can manage bank accounts, he can do this thing, the other thing, but nowhere in there is a paragraph that says that he, as the power of attorney, can create a trust for his dad. We're stuck. If that language is not in the power of attorney, if it doesn't expressly say that he can create a trust, then he cannot. And now the only solution is that we have to go to the guardianship court, file a guardianship petition, go to the judge and say, this guy is not competent any longer, have 3 doctors review that situation, prove to the judge that he's not competent, and then prove to the judge that this son should be the guardian for his dad. And we jump through all of these hoops, which takes time, by the way. And that time that you're doing this, it's a situation where you're not eligible for Medicaid. So we're racking up a private pay bill every month. That's a lot of money. And when we finally get this guardianship in place, then the son as guardian can sign the income trust. That could take multiple months. And we're spending a lot of money to jump through those hoops. Why? All because this piece of paper, this power of attorney document, doesn't say that the person can create a trust. I see this more often than you can imagine. And it's not just by somebody that goes on the internet to get the power of attorney and downloads it, fills all the blanks in. It's from other lawyers that have drafted power of attorneys for their client. The client really doesn't know any better. They're assuming that that document is done correctly, but it doesn't have the language that it needs to have in there to create a trust. Huge problem. So I guess if I'm saying, if I'm giving you some advice for everybody that's listening, is you might want to pull out your power of attorney document and read through it. There's a lot of words in there. I know that. But you might want to see if there's somewhere in that document that says that your backup person, your power of attorney person, has the ability to create trusts on your behalf. If they don't, you you should update your document and get one that says the right things that are in there. So little hit on power of attorney situations.
Yeah.
So let's do a quick little review on the Medicaid side of things. It's super important because it's going to allow us to pay for the cost of care in a nursing home. Footnote, also for an assisted living facility or care in the home. Should probably take a half a second and talk about that distinction. In Florida, there's really two different flavors of Medicaid that come into play when dealing with providing care. For lack of a better way of saying it, there's I kind of call it nursing home Medicaid, one flavor. It's like ice cream. You got chocolate over here. And then you have home and assisted living Medicaid. That's the other flavor. Let's call it vanilla. Now they're all ice cream, but they're different flavors. And they are different in how they act, how much they pay for, and how you can qualify for those benefits. The nursing home side, as we've been talking about, pays for all of the cost of care minus the contribution of that person's income. That's really a big deal. And there's no lines, no waiting. If you meet all the eligibility requirements, you're in a nursing home, basically you're qualified for Medicaid and you'll go on to the program. However, on the other flavor, the home and assisted living flavor, it plays a little differently. And that flavor of Medicaid, first of all, it does not pay for all the cost of care. It only pays for a portion of the cost of care. Let's say between $1,200 to $1,500 a month towards the cost of that care. There's some variation there because not only is it paying or helping pay for the care inside the assisted living facility or the nursing home, or the home care, but it also provides some added benefits like a Medicare supplement. Medicaid will act as your Medicare supplement, which means if you have that coverage, you can drop it. If you didn't have that coverage, you now do, which effectively means you will not have any out-of-pocket expenses for your medical care inside of a hospital or with your doctor. It also provides for a subsidized Part D plan. In essence, now it's going to pay for all the costs of your medication. So if you have a Part D plan and you're paying for that, you can drop that because Medicaid effectively is going to substitute in for that. And you actually also get a $170 a month raise on your Social Security because when you're on this flavor of Medicaid, Social Security will stop taking out your $170 Part B premium. Now, I know it doesn't seem like a lot, $170 a month, but when we're dealing with providing for the cost of care, literally every little bit helps. So that's why we get in this situation. About $1,200 to $1,500 on average is what Medicaid will help us defray the cost of care. That's a big deal. The other problem, however, with Medicaid, not problem, but difference, I guess, when Medicaid in a situation where you have providing care inside the home or an assisted living facility, there's a waiting list. This flavor of Medicaid has a limitation on how many people can participate on the program at any given time. In Florida, Florida caps or limits the amount of people that can be on this type of Medicaid. It is literally rationed healthcare. And what that means for my clients is that I can't qualify you for Medicaid for home care or assisted living care like the same way I can do under the nursing home side of things. Because even if you meet all the eligibility requirements, there's no room at the end. There's no position available on the program for you. So what the state of Florida has done is they've created, in essence, a waiting list for this program. Now, this waiting list, they call the enrollment management system. Yeah. I always thought that was overly bureaucratic and gosh, they have to always make things so complicated, but it's actually a good name for this because even though we think of it as a waiting list, it's a little different. This list, this group of people that are trying to get on the program, you are not prioritized on that list by when you got on the list. It's not a first come, first serve situation. It's prioritized based upon how sick you are versus everybody else that's trying to get onto the program. So the analogy I use a lot of times with clients is it's kind of like Outback Steakhouse on a Friday night. When you show up in the foyer to get a steak, to get a meal, there's a lot of people there and there's no seats available because all the tables are full. So they put you on a waiting list. that waiting list is prioritized by the first person that got there. They're the one who gets the next table. That's not how this works. This works a little bit differently. It's not the first person that got into the foyer that gets the next table. It's the hungriest person that gets the next table.
Yeah.
And I think that kind of paints a picture of, this prioritization on this list. And what that means is a lot of people are like, oh man, I'm not on that list. I'm never going to get picked. It's going to be forever and forever. It's going to take, all these people are in front of me. I'm never going to get a meal. Right. Well, that's not, again, the way it works. It's how sick you are versus everybody else that's trying to get onto the program. So what the state of Florida does in these cases is there is an interview process over the phone where they ask the client or the client's caretaker, caregiver, a bunch of questions on exactly how sick is that person? What can and what can they not do? How bad are they? And so it's about an hour and a half interview process over the phone. They then, all that data then kind of goes into their computer. And when a position comes, when a position comes available for the program, I always envision them pressing the button and a little piece of paper pops out. And that has the name of the next guy who gets the next slot that's available on the program. I don't think it's exactly like that, but it kind of does work like this. So when they do this interview with you over the phone, they're going to put all this information in the computer, and the computer will literally spit out a score. They will score and rank you as to how sick you are. Now, basically, it's a 1 through 5 rating, 1 being healthiest, 5 being sickest. So you'll get a letter from the agency that says you have a priority ranking score of, and there'll be a number. If that number is a 1, you shouldn't hold your breath. You're not going to get fed anytime soon. Okay. If you have a ranking of a 5, our experience is showing lately that anywhere between 2 to 4 weeks, you should get an invitation. That's the way we look at it, to participate on the program, where they say, hey, we have a position available. Would you like it? And that comes in another letter saying that you have X amount of days to file an application for Medicaid benefits. So without getting too technical, if I have a client that reports back to me that they have a priority ranking of 5 on a Monday, by Friday, they're in the office and we call it game time, basically. It is time to make sure that all of our financial eligibility numbers are correct, all of our assets in the right place, all of our income is correct. We start collecting all of the verifications of all of this information in preparation for filing an application for Medicaid benefits, because it's kind of go time at that point in time. If the client reports back, hey, I got a 1, well, let me know if things change, because I don't think you're going to get a letter anytime soon. So interesting, very interesting, actually. So back to the summary. We've been talking about income. We talked about assets. You can only have so much assets. You can only have so much income. If you're over income, you can use an income trust to fix that problem. That's a thumbs up. Make sure that your power of attorney has a provision that allows your backup person to create such a thing. If you don't have that, you need it. You need a new power of attorney in order to fix that. If you have too much assets to qualify, do you need to start getting rid of those assets now? No, you do not. It's maybe an issue. That's something that we sit down with a client or a prospective client and look at the totality of their circumstances to see what all the facts are. And does it make any sense that under your circumstances, should we start solving the asset problem now, or should we just prepare for solving it in the future? Again, very factually dependent on which way you go. But one thing that you should not do in order to qualify for Medicaid benefits, and it's one thing that's the first thing in everybody's mind. Oh my goodness, Sean says I have too much income. I mean, too much assets, excuse me. He just said I can only have so much assets. Well, I just looked at my bank account and I got too much money to qualify for Medicaid benefits. Well, I'm going to fix that problem, the person says. And so they get their checkbook out and they write a check to their son.
Right.
Well, I got too much. Well, here, I don't got that much anymore. I just gave it all to my kid. Now that seems like a solution to the problem. And I agree. It seems like a solution to the problem, but that act of giving that money to your kid is violating Medicaid's first commandment. And Medicaid's first commandment is thou shalt not give your assets away to qualify for Medicaid benefits. If you do that, if you actually give your money away by just writing a check to your kid, he cashes it, goes into his bank account, that will create a penalty. And the penalty is disqualification from Medicaid benefits
Wow.
for a period of time based upon how much money you gave away. And here's where things get really kind of, I almost say mean in a sense, is that the federal government has in recent times changed the rules on how they calculate this penalty. Back in the day, the penalty for giving some money away, that time period would begin when the check was cashed, when the money left the guy's account. That's not the way it works anymore. In order to set that penalty clock ticking, you have to basically be in the nursing home, apply for benefits, and get denied before the clock ticks.
Oh,
So what that means is right at the time that you actually need Medicaid, and 58 months ago, you gave some money to your kid, that is going to disqualify you now prospectively into the future for multiple months based upon how much money you gave away to that kid. It's a really bad thing. Giving money away like that is contraindicated, as they say. It's not a good solution and creates a problem. Now, this is called a transfer penalty. Thou shalt not make a transfer. It is subject, however, to a time period where Medicaid is looking back in time to see if you've committed this foul. So let's say you did it 30 months ago. Okay, that's within the time period. You did it 61 months ago. That's outside the time period. So what Medicaid does is Medicaid looks back in time from the date that you're applying for benefits 5 years backwards in time, 60 months. If in that time period you gave assets away, Medicaid is going to add up all of the gifts that you made, not just the one, but all of them into this kind of super transfer. And then they're going to disqualify you based upon how much money you gave away in the last 5 years.
Sean,
Yes.
someone just asked, does giving money away also apply to 501c3 foundations?
That's a great question, actually. Doesn't give away, it doesn't matter who you give the money away to, in other words. Can I give it to the Alzheimer's Association, the
Right.
United Way, the Red Cross? No, you can't. The Medicaid rules do not make any kind of exception the fact that you're giving it away to nice people who are doing good things with your money. You can't give it away to your church. You can't give it away to the capital contribution fund to put a new steeple on the church. Tithes are disqualifying acts. Contributions to charities are disqualifying acts. In essence, there's only two people that you can give money to. One is if you're married, you can give money to your spouse. I'm not really sure that gets us very far down the road because they're still counting her money. If I give it away to my spouse, it's still our money. So it really hasn't gone anywhere. And the other exception, I say the only other way that you can give money away without having a negative impact is if you're giving it away to a disabled child of yours. So children, you don't have to be young to be a child. We're all a child of someone. So if you, as the Medicaid applicant, gives money away to your kid and that kid is disabled, let's say is receiving Social Security disability income, SSDI, then that movement from you to that kid is not a disqualifying transfer. So spouse and disabled child are basically the only exceptions to the rule.
Okay.
Good question. Good question.
Now someone asked another question because I don't want to miss it.
Oh yeah, what's that?
And it says, hold on a second. They're really starting to. I am on Medicaid for Part B in Georgia. If I
Yep.
change my Medicare plan to Florida, does my Medicaid transfer with it? I just moved from Georgia to Florida.
Good question. Remember I said that Medicaid is state specific in that it's really you are qualifying for Medicaid in that state. So let me give you an example. There was a client of mine whose husband and wife had Alzheimer's disease, was progressing down that particular trail. Husband came to see me to help figure out how we're going to pay for the cost of her care when he was no longer going to be able to do that. So that's an important thing. We put our heads together. We put a plan together. We started repositioning and protecting some of the assets. And then the woman's, it was a second marriage, the wife's 3 daughters come down from the state of Michigan and take mom out to lunch in Michigan. So off she goes. She left to go to lunch. She never came back. They took her to Michigan. And this was kind of mind-blowing because nobody told us or talked to us or discussed any of this with us. Next thing we know, she's in Michigan. And the daughter, who I made power of attorney, by the way, with my power of attorney document, then lawyers up, tries to qualify mom for Medicaid in Michigan, cannot do it because of what transpired in Florida, and then files a petition to determine to get a guardian for mom up in Michigan. And I'm like, why does she do that? She's power of attorney. She doesn't need a guardian. Well, I know why she needs a guardian, because she's getting ready to file a divorce action to divorce the guy down here in Florida as mom acting as her guardian.
Oh, wow.
So it went from we got this solved to total absolute destruction. And the reason why was because they moved to a different state. So when you move from one state to another, if you're already on Medicaid in that state, you have to reapply for Medicaid in the new state. So if my client is on Medicaid here in a nursing home, they want to move mom up north to be closer to the family, and we're going to put her in a nursing home in New Jersey, you better talk to me and the New Jersey elder law attorney to see whether or not that's going to work at all. Because there's a very good chance that what transpired to qualify that person here may actually disqualify them for Medicaid in the other state.
Okay, this person says, my Medicaid only covers the Part B of the Medicare.
Yes. And I know of this program. Let's quick little visual. Medicaid is like an umbrella. It says Medicaid on the outside of the umbrella. And underneath that umbrella, there's all of these different types of programs. So in Florida, what we call this is a QMB program, or SLMB, more acronyms. But basically what this does is it pays for the cost of care for your Part B. And what that means is Medicaid comes in and says, hey, we're going to help you out, and we're going to pay the $170 for you so you don't have to.
Right.
And that can be a big deal. I don't know, to be honest with you, whether or not that would change from Georgia to Florida. My suspicion is it would change, conceivably, yes. Okay. It's a little bit of a different program. It has different eligibility requirements than Medicaid for nursing home care does. And I don't play in that sandbox very often, so I don't have an answer that I could say unequivocally that it would or wouldn't. My thought is that it would affect your eligibility, possibly moving from one state to another.
Okay.
Okay.
Another question.
Yep.
What if my mother pays me so much per month to care for her?
Oh, what a great question. I love that. Remember we were just talking about giving money away was a bad thing, like really, really bad thing.
Right.
So when mom writes a check to son or daughter, what is that check for? So if that check is for, hey, it's just a gift. I just love you. Just want to make sure that you're taken care of, and, go buy yourself something nice, or here's some for a new car, or let me help with your down payment, or here's some money for little Johnny's, college tuition, or whatever. All of those things would be gifts. Those are all transfers. However, if mom's paying you to provide care for her, that's not a gift. That's a payment. And that's totally different under Medicaid law, and is okay, and is not going to disqualify you. The problem that you run into, however, is that Medicaid doesn't really always believe you. Oh yeah, right. Yeah, that $30,000 was a payment. Really. So they're going to treat it, Medicaid, when I say they basically look at every movement of money as a disqualifying transfer unless you can prove that it wasn't. So when it comes to paying somebody, my recommendation in that situation is make sure that you formalize that agreement. So it's not just a check showing up in the son or daughter's account, that there's some sort of written agreement that says, I'm going to do this for you, mom, in exchange for you paying me X amount of dollars. Yes, mom, you moved into the house. I'm going to rent you that room and I'm going to charge you X amount of dollars per month to help pay for some of your care, and you're going to agree to pay me. So now you have an arrangement that's pretty much clearly a payment situation and doesn't look like a gift. So yes, you can be very careful and make sure you document it so that you have proof that it's a payment and not a gift.
Okay, another question. Can I put money and stock into a trust?
No.
Yes. Now, this would be a little bit of a different field. When we talk about trusts, that's oftentimes more of an estate planning situation. So when you set up, and we haven't talked about that really on this discussion yet, but when you are planning your estate and you're trying to get your assets from you to them after you're dead, one of the ways that you can do that is by using a revocable living trust to do that. And in those circumstances, it's not only can you, but you must, in order for that trust to work, put your stock and your bank accounts into the name of the trust as opposed to just in your individual name.
Okay.
Good question.
If you do not have any dependents upon death, does the Medicaid costs that were not covered during nursing home stay need to be repaid from the estate funds?
Interesting. This is, I file under the topic called Medicaid estate recovery. And this is where Medicaid is trying to recover from your probate estate when you're dead, everything that they paid on your behalf. This is kind of crazy. Medicaid doesn't actually give you any money to pay for the nursing home. They, in essence, lend it to you. And upon your death, Medicaid, reaches their hand out and says, okay, pay us back for what we paid on your behalf. Now, that's not the case in Medicare with an R. All this money that Medicare spent on your health care during your life. And when you die, Medicare doesn't reach out their hand and say, okay, well, pay us back. Medicare does not do that. Medicaid absolutely does. And that's kind of mind-blowing. So in the majority of circumstances, however, the fact that Medicaid is asking for or to be repaid, oftentimes there's never anything to repay them with, because we have moved all those assets prior, or those assets have all been spent, but those assets are gone in essence, because when the person does die, what's in their bank account? Now, if they're a single person, they have to have $2,000 or less in their bank account. If they're a married couple, all that money is in the spouse's name, and the spouse does not owe Medicaid for what her husband was paid under the Medicaid program. So that problem doesn't oftentimes come actually to fruition, but there definitely are factual situations where Medicaid does have something that they can access and that they pursue when after a person passes.
No.
Very factually specific.
Well, Sean, thanks so much for being with us today. If any of our listeners have more questions for Sean, first of all, he's located right here in Florida, in Largo, but also Sean is a guest on my radio show the first Friday of every month. So if there are any other questions that weren't answered today and you would like to get that information, please feel free to call in. And of course, all the information on where to contact Sean will be in the description of the show. So thank you so much, my friend.
I'm glad to be here. I hope that was helpful information for everybody that's listening or everybody that watches in the future. I hope that was clear and cogent and maybe shed some light into a darker space on this issue of Medicaid.
Yeah. Thank you, my friend. Have a delicious day.
All right. See you later, Linda.
Bye-bye. Well, that was absolutely fabulous. Where is my picture? Oh, there I am again. Yeah, it's always good. And ask the questions, because you don't want to get stuck when you're in an urgent situation and you don't have any answers. It's always best to talk to an attorney before the plan, before the tough stuff, so that you can get everything in order, because you have enough of everything else to think about.
Sean W. Scott has been practicing elder law and qualifying clients for Medicaid for over 30 years. While his practice is in all areas of estate planning, such as durable power of attorney, healthcare surrogates, and wills, he also prides himself on having a 100% accuracy rate on getting clients approved for Medicaid. Why Medicaid, you may ask? Do you want to pay up to $16,000 a month for a nursing home should the time come? Obviously, no one wants to have to endure this cost. So, even though you may have planned well for retirement, the reality is things happen. Planning ahead is never too soon. You need to make sure your income and assets are protected so that you can take care of you and your loved ones. Florida law is very specific on how and what is protected and how to protect it. Give Sean a call. He can help. 727-539-0181. That's 727-539-0181.